Statement of facts in California, contractual arbitration agreements can be enforced under the California Arbitration Act, CAA, Cal. Civ. Proc. Code paragraph 1280 to 1294. 2. Or the Federal Arbitration Act, FA, 9 Us. See paragraph 1-16, 201-208, 301-307. Please take special note that memorandum and reference principles are embedded throughout, for simplicity and convenience purposes. History in brief. The defendants in this matter have admitted the following. The defendants admitted that they, in combination with the Federal Reserve Bank, which are for all practical purposes, because of their interlocking activity and practices, and both being banking institutions incorporated under the laws of the United States, are in the law to be treated as one and the same bank, did create the money or credit upon its own books by bookkeeping entry. That this was the consideration used to support the notes and the mortgage associated thereto, and that this is a common practice by all Federal Reserve member banks and or institutions. The money and credit first came into existence when they created it. The Federal Reserve and the financial institutions have admitted that no United States law or statute exists which gave them the right to do this. A lawful consideration must exist and be tendered to support the note. The defendants can be charged with waiver or estoppel as a matter of law and have no defense to the plaintiff. The law leaves wrongdoers where it finds them. See sections 50, 51 and 52 of your second actions on page 584. No action will lie to recover on a claim based upon, or in any manner depending upon, a fraudulent, illegal, or immoral transaction or contract to which defendants were a party. The defendant's act of creating book entry credit is not authorized by the Constitution and laws of the United States, is unconstitutional and void, and is not a lawful consideration in the eyes of the law to support anything or upon which any lawful right can be built. The plaintiffs made misinformation to the defendants, who chose to ignore each of their requests for validation of the origination of the loan, and the matrix associated thereto. The defendants, when making the loan, violated regulations of the Federal Truth in Lending Act 15 U.S.C. paragraph 1601 and the Fair Debt Collections Practices Act 15 U.S.C. paragraph 1692, intentionally created fraud in the factum and withheld from plaintiff vital information concerning said debt and all of the matrix involved in making the loan. This establishes the existence of an obligation between the parties, and the plaintiffs contend that the bank had a contractual obligation to inform the borrowers that they were lending bookkeeping entry credit and not U.S. dollars or monies, which at the time is considered coin or currencies of the United States in general circulation as defined in statute. They failed to give vital information concerning the debt and all of the matrix involved in making the loan as required by law. The defendants were notified as to the claim of dispute by the plaintiffs, and that there was a charge of breach of the agreement, and that every instance they refused to provide a complete comprehensive accounting certified by a licensed accountant as required by law. What consumer contracts dealing with commercial transactions? This matter involves a commercial transaction, placing it within the jurisdiction of the United States Congress, who has the premier right of regulating commerce, and incorporates the Federal Arbitration Act, FAR 9 paragraph 1-16. A. The dispute. Shortly after the plaintiffs became aware of the fraud committed against them in their interest referencing a commercial contract, the defendants made several attempts to change the terms and conditions of the original binding contract, and upon the last attempt to change or alter the terms and conditions of the contract, the plaintiffs presented a conditional acceptance of offer/counter-offer whereby the defendants, if they did not agree at opportunity, to express such disagreement while complying with the duty to respond, based on the previous relationship and responsibilities/obligations then in existence between the parties, and they intentionally, deliberately, knowingly, willfully made a conscious choice to acquiesce by not challenging the new contract in any of its aspects, creating tacit acquiescence and estoppel respecting the defendants. Although not mentioned in the complaint, the commercial agreement also contains an all-encompassing, binding and enforceable arbitration clause which provides in pertinent parts as follows. Disputed matters. The defendants have agreed that any and all challenges, disputes, and other related matters were to be addressed by arbitration. Thus they have waived any and all rights and are stopped from bringing forth any challenges in the present matter. Note the agreement clause respecting arbitration, summarized here in part and incorporated herein by reference. The instant dispute is an attempt by some minority parties to the binding agreement to take over viable and thriving private properties. The dependency of the respondent's claims that litigation is a severe impediment to the rights of the plaintiffs as stipulated in the binding agreement entered into by the parties and agreed thereupon by the defendants. whose agreement was in unison. 2. Legal argument. The undersigned respectfully request that this court compel arbitration per the agreement through the amended arbitration association under its commercial arbitration rules now in effect, that such as appropriate as California has established a policy of favoring arbitration. The parties entered into a valid arbitration agreement, and the arbitration clause contained in the commercial agreement is clear and unambiguous. Moreover, none of the parties have waived the opportunity to arbitrate, as the defendants have voluntarily granted power of attorney and authority respecting such to the plaintiffs in this instant matter. As such, this court in line with statute must compel arbitration. B. The arbitration clause is valid and enforceable. Applying California substantive law, the arbitration clause in the commercial agreement is valid and enforceable. Both the California Legislature and California Supreme Court support the enforcement of arbitration provisions for alternative dispute resolution in California. The California Arbitration Act recognizes that a written provision in a contract to submit any existing controversy to arbitration is valid, enforceable, and irrevocable. The validity of such a clause initially turns on a showing that the parties have entered into an agreement to arbitrate. California Code of Civil Procedure Paragraph 1281, a written agreement to submit to arbitration an existing controversy or a controversy thereafter arising is valid, enforceable, and irrevocable, save upon such grounds as exist for the revocation of any contract. Arbitration is a matter of contract, and a party cannot be required to submit to arbitration any dispute which he has not agreed so to submit. California law, like federal law, favors enforcement of valid arbitration agreements. Any doubts regarding the arbitrability of a dispute are resolved in favor of arbitration. On motion of a person showing an arbitration agreement and alleging another person's refusal to arbitrate pursuant to the agreement. Arbitration. The California Arbitration Act, CAA, Code of Civil Procedure Section 1280 SEC, and the Federal Arbitration Act, FA, 9 Us. See Sections 1-14, a written provision in any maritime transaction or a contract evidencing a transaction involving commerce to settle by arbitration a controversy thereafter arising out of such contract or transaction, or the refusal to perform the whole or any part thereof, or an agreement in writing to submit to arbitration an existing controversy arising out of such a contract, transaction, or refusal, shall be valid, irrevocable, and enforceable, save upon such grounds as exist at law or in equity for the revocation of any contract. July 30, 1947, ch. 392, 61 Stat. 670. The courts have uniformly held that agreements to arbitrate are specifically enforceable. Any doubts concerning the arbitrability of the subject matter of the disputes are to be resolved in favor of arbitration. In the absence of the most forceful evidence of the purpose to exclude a claim from arbitration, the claim is properly submitted to arbitration. The CAA governs the enforcement of arbitral awards rendered in or outside of California, Cal. Civ. Proc. Code Paragraph 1286. The CAA generally applies to the enforcement of awards that do not involve interstate commerce or that otherwise fall outside the scope of federal statutes. Parties can also agree to apply the CAA's enforcement procedures in their arbitration agreements. The instant matter involves interstate commerce and other commercial transactions between the parties and is therefore subject to the Federal Arbitration Act as indicated in the aforementioned contract. The courts having further indicated that the parties are not to be deprived by the court of the benefit of arbitration, and any doubt is to be resolved in favor of arbitration. CAA. The arbitration statute makes clear that upon proceedings to compel arbitration the court is not to consider the merits of the dispute sought to be arbitrated. Also, all doubts concerning the arbitrability of the subject matter of the dispute are to be resolved in favor of arbitration. Once it is determined that an arbitrable issue exists, the parties are not to be deprived by the courts of the benefits of arbitration, for which they bargained, speed in the resolution of the dispute and the employment of a knowledgeable and competent arbitrator. In this case, the parties entered into a commercial agreement that clearly established arbitration as the forum for dispute resolution. Further, the parties agreed arbitration would be final and binding. As such, the parties entered into a valid and enforceable arbitration clause that should require the arbitration of the current related disputes. The Supreme Court of Nevada continues to remind all litigators that the Federal Arbitration Act governs even local disputes between private citizens and contractors. In fact, since it's the Supreme Court of Nevada in February of this year, has issued 2 more decisions reiterating that holding, recognizing the principles of law in the Uniform Arbitration Act of the state. They must be in conformity with the Federal Arbitration Act of the United States, as evidence of interstate commerce. Lanier points to 3 things. The contractor was incorporated in Delaware, much the same as each of the defendants in this matter, while the private citizens were residents of the great state of Nevada. The large number of subcontractors and material suppliers who worked on the privately owned homes made it likely that at least some of them are engaged in interstate commerce, and, in the aggregate, the general practice of developing, buying, and selling homes substantially affects interstate commerce. All of this mattered, as is the case here, because trial court judges were relying on California anti-arbitration rules to refuse to compel arbitration. Those rules are preempted if the dispute is governed by the FA. To gain exemption from arbitration, it must be specifically and expressly provided in the commercial agreement that a particular grievance is exempted from arbitration. In the absence of the most forceful evidence of the purpose to exclude a claim from arbitration, the claim is properly submitted to arbitration. Therefore, both the California Legislature and the California Supreme Court agree, agreements to arbitrate should be specifically enforced. The clause in this case expressly covers any controversy or dispute, including any dispute relating to or arising out of the action or inaction of any member/party, which is to include the defaulting party. The clause further bars litigation by stating that no action at law or in equity, before any other venue and/or jurisdiction initiated by any party shall be before and by arbitration, and with the reference to the FA, the context includes the exception, except to compel arbitration or to enforce an arbitration award. In support of the above statement, parties to contracts with arbitration provisions may be entitled as a right to compel arbitration, or simply stay the claims pending arbitration, pursuant to the Federal Arbitration Act stay provision, 9 U.S. C3. Such mandatory stays are granted in most circuits prior to a court staying non-signatory claims, either pursuant to 9 U.S. C3, or through exercise of courts' inherent discretion, or the requirements and implications of each type of stay, including appellate issues, are addressed. Mandatory stays pursuant to 9 U.S. C3, the Federal Arbitration Act, 9 U.S. See paragraph 1, et seq. FA, and the State of California Arbitration Act, CAA, embodies a liberal policy favoring arbitration agreements. The FA applies to any contract evidencing a transaction involving commerce. 9 U.S. See Section 3 of the FA states in pertinent part, paragraph 3. Stay of proceedings were issued therein referable to arbitration if any suit or proceeding be brought in any of the courts of the United States upon any issue referable to arbitration under an agreement in writing for such arbitration, the court shall on application of one of the parties stay the trial of the action until such arbitration has been had in accordance with the terms of the agreement. The Supreme Court has interpreted Section 3 as referring to parties to the litigation rather than parties to the contract. Thus, a litigant who is not a party to the relevant arbitration agreement may invoke Section 3 if the relevant state contract law allows him to enforce the agreement. Prior to Carlisle, the decision whether to stay claims among non-arbitrating parties generally was considered discretionary, except perhaps in the Fifth and Seventh Circuits. The U.S. Supreme Court has interpreted this language as signaling the broadest permissible exercise of Congress' Commerce Clause power. Challenges to the FA's applicability to construction contracts are rare and would fail under most circumstances. indicating by footnote that staying litigation among the non-arbitrating parties may be advisable, but the decision is one left to the court, as a matter of discretion, to control its dockets. A suit against a non-signatory that is based upon the same operative facts and is inherently inseparable from the claims against a signatory will always contain issues referable to arbitration under an agreement in writing, as is required for a stay under 9 U.S. C3. P. Permitting the action to proceed without a stay as to the non-signatory defendant would undermine the arbitration between the plaintiff and the signatory defendant, thereby thwarting the policy in favor of arbitration. Section 3 of the Arbitration Act plainly requires that a court stay litigation where issues presented in the litigation are the subject of an arbitration agreement. A stay must be granted, even in favor of persons that are not party to the agreement containing the arbitration clause, if the litigation is an attempt to evade the agreed-upon resolution of their disputes in the arbitration forum by introducing the identical controversy against a party who is ultimately liable for the arbitrating party's acts. Traditional principles of state law allow a contract to be enforced by or against non-parties to the contract through assumption, piercing the corporate veil, alter ego, incorporation by reference, third-party beneficiary theories, waiver and estoppel. Examples of claims by or against non-signatories that might be appropriately stated pursuant to 9 U.S. C3 include the following: third-party claims under an insurance policy requiring the insured to arbitrate claims, based on a finding that the third-party claimants are third-party beneficiaries of the policy. Claims against a contractor by its subcontractors, successors, assigns or sub-subcontractors whose agreements sufficiently incorporate obligations of the first-tier subcontract by reference. And claims by or against a parent company for damages arising out of its subsidiary's contract containing an arbitration provision, based upon equitable estoppel, agency or alter ego theories. This would also include third-party servicers, loan officers, accountants, agencies, government corporations under the Foreign Sovereign Immunities Act, and the principles outlined in the Bank of the United States versus the Bank of Georgia, where the Supreme Court of the United States concluded that a sound principle that when a government becomes a partner in any trading company, it divests itself, so far as concerns the transactions of that company, of its sovereign character and takes that of a private citizen. Instead of communicating to the company its privileges and its prerogatives, it descends to a level with those with whom it associates itself and takes the character which belongs to its associates, and to the business which is to be transacted. Thus, many states of this union who have an interest in banks are not suable even in their own courts. Yet they never exempt the corporation from being sued. The state of Georgia, by giving to the bank the capacity to sue and be sued, voluntarily strips itself of its sovereign character so far as Thus, many states of this union who have an interest in banks are not suable even in their own courts. Yet they never exempt the corporation from being sued. The state of Georgia, by giving to the bank the capacity to sue and be sued, voluntarily strips itself of its sovereign character so far as respects the transactions of the bank and waives all the privileges of that character. As a member of a corporation, a government never exercises its sovereignty. It acts merely as a corporator, and exercises no other power in the management of the affairs of the corporation than are expressly given by the Incorporating Act. The government of the Union held shares in the old Bank of the United States, but the privileges of the government were not imparted by that circumstance to the bank. The United States was not a party to suits brought by or against the bank in the sense of the Constitution. The Supreme Court went even further in highlighting the parties like the defendants to this matter at bar, that the defendants in that they are either a financial institution and/or associated with the financial institution and are an entity or agency which bears an employer identification number which is associated with a corporation, either by their charter and or by their being a part of the federal DIN identification system, have consented to being sued and having the power to sue, the act which gives jurisdiction to the courts of the Union over suits brought by the citizen of one state against the citizen of another restrains the jurisdiction where the suit is brought by and assignees to cases where the suit might have been sustained had no assignment been made. But the bank does not sue in virtue of any right conferred by the Judiciary Act, but in virtue of the right conferred by its charter. It does not sue because the defendant is a citizen of a different state from any of its members, but because its charter confers upon it the right of suing its debtors in a circuit court of the United States. If the bank could not sue a person who was a citizen of the same state with any one of its members, in a circuit court, this disability would defeat the power. There is probably not a commercial state in the Union some of whose citizens are not members of the Bank of the United States. There is consequently scarcely a debt due to the bank for which a suit could be maintained in a federal court did the jurisdiction of the court depend on citizenship. A general power to sue in any circuit court of the United States, expressed in terms obviously intended to comprehend every case, would thus be construed to comprehend no case. Such a construction cannot be the correct one. The doctrine of equitable estoppel would seem to accommodate a wide range of colorable arguments for staying or compelling arbitration of claims by or against non-signatories. Courts have stopped claimants from avoiding arbitration of non-signatory claims that make reference to, presume the existence of, or arise out of and relate directly to the written agreement requiring arbitration, or that are inextricably intertwined with claims against a signatory. In this matter the defendants have attempted to claim that the actual contractual agreement was somehow a party's amended complaint, failing to highlight on the public record that the parties have entered into this agreement to avoid litigation, and despite the entering into the agreement the defendants then proceeded to challenge the agreement and then avoid the entire arbitration issue. The agreement having been in place for more than 100 days has not had a single direct challenge by any party, nor has the power of attorney and or the rights conferred via the power of attorney been challenged by the parties, to the present day. The defendants are stopped from making such claims at present, and if they did decide or attempt to make such claims they would have to do so according to the terms of the agreement, that is arbitration. Discretionary stay is the basis for bringing non-signatories within the FA's mandatory stay provision. The decision whether to grant a stay absent federal state provisions of the FA and or the California provisions of the CAA remains within the court's inherent discretion to control the disposition of the causes on its docket with economy of time and effort for itself, for counsel, and for litigants. Parties to the two cases need not be the same, and issues need not be identical to empower a court to stay proceedings in one suit to abide proceedings in the other. We presented to the court evidence that the opposing party had not complied with the original contract. We also presented to the court evidence that the opposing party had attempted to renegotiate the contract. Then we provided the court a copy of the renegotiated contract, which included the conditional acceptance and offer, which incorporated an arbitration clause. This is not an issue as to the binding nature of the contract, but whether or not the law applies equally, and for this court the whole session in complete disregard for the principle of law, whereby having a copy of the contract on the record stated it did not recognize a party to the contract as being a party to the matter was a violation of due process. When the defendants made their appearance in court they did so without notifying the plaintiffs in the matter, which is required by law. In fact the defendants, those who made a late showing to be in appearance at the last hearing on or about November 8, 2018, did knowingly and intentionally subject the plaintiffs to undue surprise, violated the rules and procedures for the court, and these are said to be learned individuals. The very same fact that while there were challenges to the alleged foreclosures, any qualified written request having not been responded to until this very day there has been no response, the defendants went through with the sale of a property in violation of the original agreement and the law known as the Real Estate Settlement Procedures Act, which also recognizes the right to arbitration. for this court to not acknowledge the plaintiff's right as well as the defendant's right to have the matter arbitrated, as directed within the agreement, would impose an undue hardship unlike those that could ever be suffered by the opposing party. Because such would be an infringement upon due process, the laws and principles of arbitration the courts have agreed to abide by. It should be noted that when the connected or related case is in arbitration, courts are more likely to grant the discretionary stay pending completion of the arbitration, due to the policy in favor of arbitration. Claims involving non-signatories to arbitration agreements signed by their affiliate were properly stated because they were inherently inseparable from the claims at issue in their affiliate's arbitration, and arbitration would otherwise be rendered meaningless and the policy in favor of arbitration effectively thwarted. A key factor courts consider is whether the non-signatory's potential liability derives from the conduct or potential liability of a party or signatory, such that staying claims against the non-signatory likely would conserve judicial resources and minimize the possibility of inconsistent results. The most obvious type of claims were granting a discretionary stay, if not a mandatory stay pursuant to 9 U.S. C3, are Miller Act claims, which courts routinely stay pending arbitration to determine the contractor's liability. Unless general contractor were to intervene in this suit, litigation of subcontractor's claims under the subcontract would occur through the surety. Arbitration between subcontractor and general contractor therefore would be far more efficient. It was not the intention of Congress to extend or enlarge the liability of the surety beyond the contractual or quasi-contractual obligations of the contractor, who remains primarily liable. If a subcontractor could avoid the arbitration requirements in a subcontract by suing only the surety, such a result would effectively render arbitration provisions meaningless. Subcontractors' recovery rights against the sureties necessarily depend on whether contractor breached its subcontract with subcontractor. The liability of the sureties is limited to the liability of the principal, which will be determined by arbitration, and there's no reason to duplicate the determination here and risk inconsistent rulings. Miller Act sureties stand in the shoes of the general contractor and are entitled to its affirmative defenses. Staying subcontractors' Miller Act claims against contractor and surety pending subcontractors' arbitration with subcontractor. Claimants opposing a request for discretionary stay pending arbitration often argue a stay will delay recovery of damages owed for an immoderate or indefinite duration, thereby causing financial hardship. Such would be futile and a waste of the court's time, because any argument asserting such a stance would be contrary to the principles of arbitration. In a complex, multi-party dispute, issues such as the risk of inconsistent rulings, the extent to which parties will be bound by the arbitrator's decision, and the prejudice that may result from delays must be weighed in determining whether to grant the discretionary stay, and in fashioning the precise contours of any stay. Such arguments often are dismissed by courts as speculative absent a specific and compelling showing of hardship, particularly when arbitration has commenced or, better yet, a final arbitration hearing date has already been set. It is a somewhat peculiar stance to assert that delay will cause financial hardship while simultaneously requesting that the court allow full-blown litigation to proceed. One of the primary reasons why the law favors arbitration is to resolve cases more quickly and efficiently. Appealability of orders granting or refusing a stay. All that matters for appealability is that the appellant sought the stay on the authority of 9 U.S. C3, whether or not the stay was authorized by that section. If a motion for stay is denied, it will be immediately appealable pursuant to 9 U.S.C. 16A1A. See also Conrad v. Phone Directories Company, Incorporated, 585 F.3D 1376, 1385, 10th Circle. 2009. The first, simplest, and surest way to guarantee appellate jurisdiction under paragraph 16 is to caption the motion in the court as one brought under paragraph 3 or 4. This simple rule should dispose of the vast majority of cases in this area, and those hoping to avail themselves of the immediate appeal provided for in the FA would do well to follow it. Notably, dicta in the Conrad decision states, if the court suspects that the motion has been miscaptioned in an attempt to take advantage of paragraph 16a, it must look beyond the caption to determine whether it is plainly apparent from the four corners of the motion that the movement seeks only the relief provided for in the FA, rather than any other judicially provided remedy. Counsel should consider this admonition and potential implications for appealability, even if briefly, in deciding upon an alternative request for stay pursuant to the court's inherent discretion. If the court were to deem it unnecessary to state the matter pending arbitration, it would then be subjecting the state and the parties to greater expense by having an appeal filed and prosecuted, where the FA and the favorability of arbitration over litigation are the principal foundations for such an entertainment of such a request. The state law cannot not interfere with liberal policy favoring arbitration. Generally, stay orders direct clerks of court to administratively close the cases pending the outcome of arbitration, rather than dismissing the cases. Such orders are almost always interlocutory. Granting appellee's motion to dismiss appeal, for lack of jurisdiction, of an order granting appellee's motion for a stay pending the parties' arbitration proceedings, pursuant because court merely administratively closed the case without dismissing it and did not certify the appeal under 28 Us. See paragraph 1292b, had the court entered a stay instead of a dismissal in this case, that order would not be appealable. The contract is clear and unambiguous. The commercial agreement between plaintiffs and defendants clearly and unambiguously requires arbitration for all disputes. California courts consistently enforce unambiguous contracts according to their plain language. The Supreme Court in Reynolds v. the United States decided on January 23, 2012 came to the same conclusion. When considering statutory interpretation, there's the plain meanings doctrine. The contract stipulates that it must be construed contextually and not otherwise, and such a construction was agreed to by all the parties, and specifically the contract holds that in line with the FA only the arbitrator has the authority to determine the binding nature of the agreement. Courts are bound by language that is clear and free of ambiguity and cannot, using the guise of interpretation, distort the plain meaning of the agreement. In this case, there is no doubt that the parties agreed to a clear and unambiguous requirement to arbitrate. In fact, the word arbitrate appears throughout the document/instrument/contract more than 15 times. Moreover, the language clearly evidences an agreement to arbitrate disputes arising from the actions or inactions of members/parties to the agreement. Finally, it is clear from the language of the contract that the parties intended arbitration to be final and binding. As such, the contract clearly and unambiguously requires that the parties arbitrate this dispute, and this court should enforce the clear language of the commercial agreement between the parties. Holding that where a document is clear and unambiguous, the court must construe the document from its language. Concluding that a clear and unambiguous document on its face must be construed according to its plain language. Finding that commercial agreements are construed from written language and enforced as written. Needless to say, the overwhelming authority from the California Supreme Court and elsewhere holds that unambiguous commercial agreements must be construed according to their plain language. The commercial agreement clearly and unambiguously requires arbitration. The arbitration clause is clearly and unambiguously written. In particular, the provision governing disputes of the commercial agreement is wholly free of ambiguity and clearly states that any dispute must be settled by arbitration. Moreover, the commercial agreement specifically provides that the arbitration should take place according to the rules of FA. The arbitration clause was fully negotiated and executed. Thus, given the clear and unambiguous language of the commercial agreement requiring arbitration and California's presumption in favor of arbitration, the commercial agreement should be specifically enforced, requiring that this dispute be submitted to binding arbitration and that this litigation is stayed in the interim, and the defendant's claims dismissed as a result of estoppel. In the instant case, no discovery has taken place, and there has not been significant activity towards litigating either party's claims or defenses. No answer has yet been filed. no discovery has taken place. Therefore, no parties will suffer prejudice from the change of forum from this court to arbitration. As there is no prejudice, this court should compel arbitration. The court is not to consider the merits. The United States Supreme Court prohibits consideration of the merits on a motion to compel. The Supreme Court held that there is a presumption of arbitrability in the sense that, in order to arbitrate the particular grievance should not be denied unless it may be said with positive assurance that the arbitration clause is not susceptible of an interpretation that covers the asserted dispute. In ruling on the arbitrability of a dispute, a court should not decide the merits of the underlying claims. The scope of the broad arbitration clause. Generally speaking, arbitration clauses are referred to as being broad or narrow. Typically, broad arbitration clauses encompass all of the parties' disputes arising out of their agreement, whereas narrow clauses are intended to limit the disputes that are only specifically referred to arbitration. For instance, in the parties agreed to arbitrate any dispute arising out of or in connection with their agreement, and like the case at bar. The Delaware Supreme Court held that the parties had signaled an intent to arbitrate all possible claims that touch on the rights set forth in their contract. Language such as, all disputes arising out of the commercial agreement are subject to arbitration, or any dispute or controversy arising under this commercial agreement shall be submitted to binding arbitration, is equally effective in evincing the parties' intent to submit all of their disputes to arbitration. Business Law Today, Volume 18, April 2009. The arbitration clause clearly indicated the parties' intentions to arbitrate any and all disputes and/or controversy arising from the agreement and/or related issues. In or about the fall of 2016, Gregory McBride deceased, the contract with the parties that were referred to as the original contract included such a clause that made exceptions to the passing into death by a member of the agreement, which also included the federal provisions of mortgage insurance. As indicated in the complaint, mortgage insurance is a federal requirement for all conventional home loans as a result of the 1978 to 1980 financial crisis, whereby the Reagan administration, with the help of the Republican Congress, placed into law the requirement for all conventional home loans to be backed by mortgage insurance, and further backed by a government guarantee. Such a program, known as the Single-Family Home Loan Program, was instituted, conferring upon each of these conventional home loans the backing of the full faith and credit of the United States government. The contract incorporates the United States government as a party, and under the Contract Clause of the United States Constitution, the jurisdiction over such contracts rests with the United States Congress. We remind the court that it too is a party to the contract along with the state of California through the Attorney General and through the Judicial Council for the state of California, as they were parties to the contract and have consented to the agreement that is binding and irrevocable respecting all parties to that agreement. There appears to be a conflict of interest, and any adverse decision by the court may be perceived as self-serving and/or discretion abuse. Three. The Federal Arbitration Act, FA. As previously stated, the Federal Arbitration Act, the FA, or the Act, provides that written arbitration agreements are valid, irrevocable, and enforceable, save upon such grounds as exist at law or inequity for the revocation of any contract. The main purpose of the Arbitration Act is to overcome courts' refusals to enforce agreements to arbitrate. In passing the FA, Congress was motivated first and foremost by a desire to change this trend, to enforce arbitration agreements into which parties had entered, and to place such agreements upon the same footing as other contracts. Emphasis added, citations omitted. To fulfill the purpose of enforcing arbitration clauses more uniformly throughout the country, Congress established a broad principle of enforceability within the provisions of the FA. The Supreme Court has determined that Congress would not have wanted state and federal courts to reach different outcomes about the validity of arbitration in similar cases. Accordingly, the court also concluded that the Federal Arbitration Act preempts state law, and it held that state courts cannot apply state statutes that invalidate arbitration agreements. Hence, the outcome should be the same in state and federal court, applying state or federal statutes, which is precisely why we have used case law from the various states, and the various states' Supreme Court as well as United States Supreme Court, because the arbitration laws drop United States must be uniform, and the decisions rendered by the courts in reference to the arbitration laws must follow the same principles of uniformity. The conclusion: plaintiffs respectfully present this motion to compel arbitration, to dismiss the claims and/or motions and/or filings of the defendants as barred by estoppel principle and agreement, and to stay the plaintiffs' claims. The plaintiffs request that this court compel the arbitration of the dispute between plaintiffs and defendants. The parties entered into a valid, clear and unambiguous arbitration agreement requiring arbitration of claims concerning the action or inaction of any party to the agreement. A dispute has now arisen concerning defendants' actions as a member and/or party to the agreement. As such, the arbitration provision in the agreement between the parties should be given its full force and effect, and this case should proceed through final and binding arbitration before the Arbitration Association. Adequate time should be provided to defendants to file an appropriate answer and counterclaim against plaintiffs for intentionally interfering in the multi-million-dollar transaction currently pending. This lawsuit should be stayed pending binding arbitration. California law, as articulated by both the California Legislature and the California Supreme Court, as well as the Federal Arbitration Act, uniformly hold that the arbitrability of disputes agreed upon in a written contract or agreement must be enforced. Moreover, California law consistently enforces the clear and unambiguous language of contracts, particularly broad arbitration provisions such as that presented here. In this case, the clear and unambiguous contractual provision requires arbitration of any disputes and/or controversies arising out of or related to the commercial agreement. Pursuant to both the California Arbitration Act and the Federal Arbitration Act, this dispute should immediately be submitted to binding arbitration and this litigation stayed in the interim. Memorandum Table and Authorities, Legal Standard Federal Arbitration Act FA versus California Arbitration Act CAA. Petitioner has filed its motion to compel arbitration pursuant to the FA. If a party to an arbitration agreement files a case in the district court that is covered by the agreement to arbitrate, the FA permits the aggrieved party to file a motion to compel arbitration pursuant to their agreement. A dispute between the parties as to whether the claims are arbitrable in the first place, that is the arbitrability question, is governed by the FA or the CAA. The statutory language of the FA provides that it applies to contract evidencing a transaction involving commerce to settle by arbitration a controversy thereafter arising out of such contract or transaction. The language involving commerce in the FA has been interpreted to mean the functional equivalent of the more familiar term affecting commerce words of art that ordinarily signal the broadest permissible exercise of Congress' Commerce Clause power. Therefore, absent a clear and unmistakable designated intent that non-federal arbitrability law applies, federal law governs the arbitrability question by default because the agreement is covered by the FA. Generally, in deciding whether to compel arbitration, a court must determine two gateway issues. 1. Whether there is an agreement to arbitrate between the parties, and 2. Whether the agreement covers the dispute. The party moving to compel arbitration bears the burden of demonstrating that these two elements are satisfied. Agreements to arbitrate may be invalidated by generally applicable contract defenses, such as fraud, duress, or unconscionability. Arbitration is a creation of contract, and a court will not grant a motion to compel arbitration unless it finds that there is a clear agreement to arbitrate. When determining whether a valid contract to arbitrate exists, we apply ordinary state law principles that govern contract formation. A party's acceptance of an agreement to arbitrate may be express, as where a party signs the agreement. Acceptance of an agreement to arbitrate is implied in fact where the conduct of the contracting parties suggests such acceptance. Employee's continued employment constitutes her acceptance of an agreement proposed by her employer. In resolving a motion to compel arbitration, the court applies a standard similar to that of a motion for summary judgment brought pursuant to Rule 56 of the Federal Rules of Civil Procedure. Citations omitted. The party opposing arbitration receives the benefit of any reasonable doubts and the court draws reasonable inferences in that party's favor, and only when the arbitration agreement's existence and applicability may the court compel arbitration. The FA does not require the absence of any factual dispute. Rather, there must be no genuine issue of material fact. Emphasis is in original, a material fact is genuine if the evidence is such that a reasonable jury could return a verdict for the non-moving party. Conversely, here the record taken as a whole could not lead a rational trier of fact to find for the non-moving party. There is no genuine issue for trial. The court looks to the four corners of the agreement to arbitrate disputes to determine whether the parties clearly and unmistakably designated intent for non-federal arbitrability law to apply. The parole evidence rule generally prohibits the introduction of any extrinsic evidence to vary or contradict the terms of an integrated written instrument. That agreement states that California law is to be applied by the arbitrator to disputes that are subject to arbitration, but it is silent as to whether California law also applies to determine whether a given dispute is arbitrable in the first place. Given this silence, federal law must be applied here by default to determine arbitrability. Federal arbitrability law, rather than English law, applied in determining whether boat owner and salvage company had agreed to arbitrate arbitrability of dispute, where agreement was ambiguous concerning whether English law also applied to determine whether a given dispute was arbitrable in the first place. Effect of Federal Arbitration Act, where the FA is applicable, as it is here. The U.S. Court of Appeals for the Ninth Circuit has summarized its impact on interpretation and enforcement of arbitration agreements as follows. The Federal Arbitration Act (FA) requires courts to place arbitration agreements on an equal footing with other contracts, and enforce them according to their terms. Section 2 of the FA makes agreements to arbitrate valid, irrevocable, and enforceable, save upon such grounds as exist at law or in equity for the revocation of any contract. The final clause of paragraph 2, generally referred to as the savings clause, permits agreements to arbitrate to be invalidated by generally applicable contract defenses, such as fraud, duress, or unconscionability, but not by defenses that apply only to arbitration or that derive their meaning from the fact that an agreement to arbitrate is at issue. In favor of arbitration. Section 2 of the FA preempts state statutes and state common law principles that undercut the enforceability of arbitration agreements, unless the savings clause applies. In other words, a court cannot enforce state laws that apply to agreements to arbitrate but not to contracts more generally. C. Any general state law contract defense that has a disproportionate effect on arbitration is displaced by the FA.